Hopefully that's loud enough.
We'll
Good
let
morning.
you know if it's not.
Thank you.
He
Good
usually
morning,
makes
Your
some kind of face or something to let us know.
Sounds good. Good morning, Your Honors. May it please the Court. Jessica Butler with the Appellate Division of the Public Defender's Conference on behalf of the appellant, Mr. Ralph Overstreet. Judge Ayers, if I could request 3 minutes for rebuttal. Thank you. We've raised 3 issues in our brief, but for today I will rest on our brief with regards to the sufficiency of the evidence and focus on the actual conflict that arose based on the ADA's prior representation of Mr. Overstreet, and we'll also touch on the discovery violation that occurred. Beginning with the actual conflict, just for a brief recitation of the facts, Mr. Overstreet was charged with several offenses, the most serious of which being attempted first-degree murder as a result of an altercation with a police officer during what appeared to be a mental health crisis. Mr. Overstreet was charged, tried, convicted, and proceeded to a sentencing hearing that ultimately occurred in 2 parts. At part 1 of the sentencing hearing, the state admitted certified copies of judgments. It was at that point that trial counsel noticed that ADA Baer was listed as the defense attorney on 2 of these judgments stemming from 2008. Trial counsel objected, argued that this was a direct conflict, and asked the trial court to continue the sentencing hearing. So the parties reconvened approximately 2 weeks later, this time with a new ADA taking over the case, and at that point trial counsel asked the trial court to declare a mistrial. The trial court denied that request, and Mr. Overstreet was ultimately sentenced to an effective 41-year sentence. Mr. Overstreet is now entitled to a new trial because of ADA Baer's involvement in this proceeding. He had an actual conflict that disqualified him from participating in this prosecution. I do want to note just sort of the lay of the land at this point. This is sort of an open question. There is at the moment a split of authority amongst the Court of Criminal Appeals. There are several cases that the state has cited to in its brief that do seem to indicate that this is not an actual conflict. Although I do want to point out that most of those are in a different procedural posture, and I do think that changes the analysis some. But of course, in our brief, we relied on State versus Edie that this court decided last year, or no, not last year, 2022, where the court found that there was an actual conflict where the District Attorney General previously represented the defendant and then used that conviction as a means to enhance his sentence. Of course, State versus Edie is currently pending before our Supreme Court, and that was heard, I believe, in May. So the ruling is likely imminent, and certainly whatever the court decides there will probably directly impact this court's ruling in this case. So I do want to make that note. But regardless, I do think that the rules of professional conduct here still require a reversal.
Let me ask you this. If there is an actual conflict, was an actual conflict in this case, what is the prejudice to the defendant?
So I think the prejudice is sort of not exactly the appearance of impropriety, but the idea that an attorney can establish a relationship with a client and then several years down the road use that relationship in a sense as a sort of a weapon against them later on.
Well, how is there any proof that that was used when it was not even known until the sentencing hearing? I mean, lawyers are a lot more transitional, mobile
Sure.
these days, and change jobs a lot. We see a lot of attorneys going back and forth, especially to and from the public sector.
Right.
And especially if you're in the criminal defense world, you're going to touch a lot of people during any of that type of representation. So yes, I think the rules tell us there needs to be screening processes in place, and there are conflicts that arise, but I think it's just common sense that something like this is going to happen. And when it does, again, I go back to what is the prejudice, and certainly if there had been an instance where that attorney knew it on the front end and somehow did use information to the detriment of the prior client, I could certainly see a significant issue there. But that's not what we have in this case, is it?
So there are a couple things I want to touch on there. The first being that I think it's important to note that the rules don't actually require that there be some sort of prejudice to the client. The rules only say that attorneys are disqualified from participating, and there doesn't say that there needs to be some sort of prejudice to the client if that occurs. That's number one. Number two, I think part of the problem we have here, because this ADA was the lead attorney in this case, and candidly, this wasn't fleshed out as well as it maybe could have been at the motion for new trial, but we don't actually know that there wasn't some information that he obtained in that prior representation that he then used here.
But wasn't there information that they claimed, at least in open court to the court, representing to the court, that they were unaware that that attorney had previously represented the defendant?
Defense counsel was unaware, but there's nothing in the record to indicate that the ADA was unaware that he'd previously represented Mr. Overstreet. And that's actually how I think this case differentiates a bit from State versus Dixon that the state cites in its brief, because part of this court's analysis in that case was that the ADA did not remember representing that client at the time. That's not what we have here. In fact, when this came out at the sentencing hearing, at no point did the ADA say, I don't recall representing Mr. Overstreet, I didn't know, this is brand new information to me. The first thing he says is that I didn't disclose anything that I learned during that representation. He actually doesn't even say I didn't use anything, just that I didn't disclose anything, presumably to the attorney that sat second chair, and then ultimately handled the second portion of the sentencing hearing. So I do think that that's part of the analysis here, that we don't actually know. It's difficult to sort of get inside someone's head and determine what they knew, what they didn't know, what they used, what they didn't use, especially because it could be something that on the surface might seem fairly innocuous, and then as you get into the case, that might be something that might actually be beneficial to the state to know about Mr. Overstreet, that we wouldn't otherwise know because we can't actually get into.
You're saying there's not even really much detail that wasn't pursued very in depth at the motion for new trial hearing?
To be candid, no, it was not. There probably could have been more done to flesh that out, but with the record that we do have, I think it's pretty clear that the ADA at no point said that he didn't remember representing Mr. Overstreet, only that he didn't disclose anything that he learned as a result of that representation.
Did he testify at the motion for new trial hearing?
He did not.
So that was just a statement that the ADA made in open court?
Yes. Yes, when the trial counsel looked at the judgments that were submitted at the sentencing hearing and noticed that the ADA's name was on two of the judgments, brought it to the trial court's attention. They sort of take a break and...
So what should the trial attorney have done at that point? Call the ADA as a witness at the motion for new trial? Is that what you're suggesting? It could have been done better?
I think that would probably give this court more of a
well,
record.
without that in the record, we're left to speculate, correct?
Correct. I think that would definitely give the court more to work with if that had been done. Of course, it wasn't, so we are sort of stuck with what the record does have, which is simply that he doesn't appear to not remember representing him, just that he didn't disclose anything that he learned during that representation.
And the representation, as I recall, was 10 years previous. Is that correct to this trial?
A little bit more than 10 years, yes.
Over 10 years.
Yes.
Do you think that's significant? Is that a factor that we should consider?
I think it can be. I think that is potentially part of the analysis. But the one thing that I do want to point out here is that sort of the situation we have here is that he represented Mr. Overstreet on two plea agreements. So Mr. Overstreet pled guilty to the two offenses that are here were both guilty pleas. And I do want to point the court's attention to comment 3A to Rule 1.9, which talks about what constitutes a substantially related matter. Obviously, the rule indicates that you can't participate in the same matter, and also you can't participate in a substantially related matter. And there's an example in comment 3A that I do think is instructive. It says that the lawyer may not, on behalf of a later client, attack the validity of a document that the lawyer drafted if doing so would materially and adversely affect the former client. And just sort of to draw that out into the criminal context, I think this might be a different situation if Mr. Overstreet had proceeded to trial with the ADA as his attorney, was ultimately found guilty, and then that was the conviction that we were using to enhance his sentence. But I do think it's a bit different when the attorney sits down with their client, offers them a plea deal. We don't know what was bartered for. We don't know what was left on the table. All we know is that Mr. Overstreet took his attorney's advice and pled guilty instead of exercising his right to go to trial, where he potentially could have been found not guilty.
And if I understand your argument, you think it's more prejudicial to the defendant that he and the former attorney worked out a plea deal as opposed to going to trial?
I think it can be. I do think it can be, because it's...
I would think it's the other way around, but...
I think looking at that comment, I do see sort of a similarity between the example that's in the comment and then what happened here, because you're essentially drafting something for a client and then turning around and using your own work sort of as a weapon against them later on, which is, in a sense, the same thing that the comment points out. So I do think that it could be a different situation if he had been his attorney and they had proceeded to trial. But the fact that there was a plea agreement, there is some level of trust involved in that when you decide to exercise, give up your right to a trial and take your attorney's advice. And then ultimately that ends up coming back to bite you later from the same attorney. If there are no further questions on the actual conflict, I'll move to the discovery violation quickly. Okay. So the state violated Rule 16 of the Tennessee Rules of Criminal Procedure when it failed to hand over Mr. Overstreet's recorded interview in full. Mr. Overstreet filed a motion for discovery very early in the process, specifically citing Rule 16 and also asking for notice of any prior bad acts. So that motion should have covered everything that was in the recorded interview that Mr. Overstreet did with Agent Bellotti. Instead, what happened, even though the state filed notice that it had turned everything in discovery, at the trial, Agent Bellotti testified that Mr. Overstreet told him about an altercation he had with his girlfriend roughly 24 hours before this event, where he blacked her eye, is what he said.
And so was that information not in the recorded interview?
That is our position, that was not in the recorded interview. When this came out at the trial counsel immediately objected, said this is the very first time we've heard this. That was not in the discovery that we received. And again, the ADA doesn't actually say, no, you're mistaken, it was in the motion, it was in the discovery. It's sort of hard to read in the record.
Do we have the recorded interview?
We do not. So the recorded interview, ultimately what the state did was they took the recorded interview and sort of spliced it into, I believe it was 10 clips. And the 10 clips were what was produced at trial.
So we don't have the full recorded
do
interview
not
to know
have the
whether or
full-
not it was in there.
We do not have the full recorded interview. We have the 10 clips, and it's definitely not in the 10 clips.
But the 10 clips was prepared to avoid having this alleged assault that had nothing to do with this case told to the jury. Am I wrong about that?
I think that was probably part of it. It's not explicitly stated in the sort of conference they have before the jury comes back in. It's not explicitly stated that was part of what was taken out, but the ADA did say that he had gone through and taken out everything that he thought would be prejudicial. But again, it's our position that this portion, this discussion that the agent talked about in his testimony was not in the recorded interview that we received.
Okay, I'm sorry. If it had been, you'd have been jumping up and down, or the defense attorney would be jumping up and down about that having nothing to do with this offense, correct? And it needs to be out.
Well, I think either we would have dealt with that pre-trial, or if it came out, then we would have addressed it at the time. But I think best practice, we would have addressed that pre-trial.
So are you speculating that there was more that could have been helpful to the defendant that was cut out of the statement?
No. Just that this was a prior bad act that was included in the interview that we did not receive notice of.
That you did not want the jury to hear about?
We did not want the jury to hear it, and
so
we did
how
not
are you
receive
prejudiced?
notice.
How's the defendant prejudiced?
Because ultimately this testimony did come out, And when it did come out, obviously the trial court gave a curative instruction, but it's our position that that was not a sufficient remedy, because once it's out, it's out. And it was, the testimony itself was of such a nature that it's difficult to just sort of assume that the jury is going to disregard that.
But it came out in live testimony, I guess, from this agent.
It did, yes.
Not on the recording.
Not on the recording. It came out during live testimony, and that was based on questions from the district attorney. So it didn't just like sort of he was talking and it came out. He actually was pointedly asked questions by the district attorney, and then this came out. Obviously, Mr. Overstreet was on trial already for an act of violence. This is another act of violence that allegedly occurred approximately 24 hours before, and just based on the nature of the offense that he was already on trial for, as well as the nature of the allegations, even the curative instruction would have been insufficient to cure that.
I may have misread this, but I thought somewhere I saw that there was an acknowledgement by the defense counsel of receipt of the recorded interview.
We received a recorded interview, but again, it's our position that this discussion was not in the recorded interview that we received. So either
But that wasn't known at the time and made part of the record?
I'm not sure I understand your question, sorry.
Well, I think it was just, I thought there was just an acknowledgement, yes, Your Honor, we've got the recorded interview. So you're saying that they didn't know at the time they made that acknowledgement that it was missing information? Or it wasn't the
Correct.
full-
So we did not know, we don't know what we don't know, right? So we didn't know that this information wasn't, we didn't know that this information was out there to begin with, let alone that it wasn't in the recording that we received. We did receive a recording in discovery. Obviously, we've gone through it. It was spliced. We had an opportunity to look at it again before it was presented to the jury. And then it was during that testimony that this came out. Number one, I think it's clear we have a discovery violation. I know that that's part of the state's argument, that they did comply with the rule. I think that the record is fairly clear that they did not. I think even at the motion for new trial, they sort of tacitly acknowledged that they didn't. Their only position there was that the curative instruction was sufficient. So I think it's pretty clear in the record that there was a discovery violation and that the curative instruction that was given was not sufficient. So if the court has no further questions on that, we'd ask the court to reverse on one or both of these and remand this for a new trial. Thank you.
Thank you. General Weldon?
Good morning, and may it please the court. Caroline Weldon on behalf of the state. This court should affirm the defendant's convictions because the trial court acted within its broad discretion by finding that no conflict of interest exists and the state did not violate Tennessee Rule of Criminal Procedure 16. Beginning with the first issue, the defendant claims that ADA Baer should have not prosecuted the state's case because he represented him in prior unrelated criminal matters more than 10 years earlier. But ADA Baer did not have an actual conflict of interest because he did not represent the defendant in this case. And nothing in the record suggests that ADA Baer disclosed or leveraged any confidential information obtained during his prior representation of the defendant for this trial.
So are you saying there's not a conflict ever if it's not representation on the same case?
I'm saying that there was no actual conflict of interest in this case.
But it did sound like you said because he was not, the ADA was not involved in this case. Let's suppose in private practice I represented somebody that was defended on a murder case, and then later on I'm a DA and on a different case. Do I have a conflict at that point to prosecute on a different case, different charge, when I had represented this defendant before in a criminal or in, let's say, homicide murder case?
I don't think that you would automatically have an actual conflict of interest by being on both sides of the aisle with the same defendant. I think, of course, in that scenario, if you were to have used information that you would have learned from the defendant during that prior representation, that could be called into question depending on the circumstances in that hypothetical. But here, for this case, there was no actual conflict of interest. Again, ADA Bear represented the defendant more than a decade ago in 2 totally unrelated offenses, and those convictions for those offenses were factored into his range status for purposes of sentencing in this case. As counsel noted, our Supreme Court has not yet ruled on the specific issue of whether a district attorney may represent a defendant and then subsequently prosecute the defendant in an unrelated matter.
Well, let me say this, the Edie case was a little bit different in that the attorney who had the conflict in that case was not the hands-on prosecuting attorney. It seems like in this case, General Bayer was, ADA Bayer was the actual attorney. Is that a distinction we need to look at?
Well, I think turning to this case, ADA Bayer was the lead attorney at trial. There's no question that he was the main person prosecuting the defendant in this case. But as far as what we can glean from the record, his involvement with the defendant for those 2 prior representations was pretty minimal. It seems like he only represented him for purposes of sentencing, and that then those certified convictions were incorporated for the notice of enhancement.
He didn't represent him for the whole thing, for the plea?
Well, for the plea, yes, Your Honor.
Okay.
But again, as far as we can tell, it's not as though he was representing him at a very long trial over a period of several years. It seems from, again, what we can tell, yes, he signed the plea agreement paperwork, but we don't know anything else about the scope of his representation or his...
Well, Ms. Butler seems to be suggesting that it's more egregious that it was a plea agreement that he represented him on as opposed to an extended trial, full-blown trial.
Yes, I heard that mentioned earlier, and I think I agree with you, Your Honor, that I'm not sure how that would be more egregious.
Well, does it matter at all? I mean, representation's representation.
Well, I think if you're looking at what ADA Bear's advantage could have been because of this prior representation, if they had a very brief moment where he stepped in to help do a kind of perfunctory plea agreement versus representing him over a very long, extended trial.
But you're speculating about that. I mean,
yes, because the record...
I wouldn't say that representing someone to a plea agreement is just a short perfunctory matter. I mean, sometimes that can take years to negotiate and work a case to get to the point of a plea.
Of course, Your Honor, yes, and that's certainly true. It's just that's not encapsulated within the record.
So we don't know.
We don't know, exactly. We don't know. So it's a lot of reading between the lines. But as far as one can tell from the record, it would appear that his representation was, at least he only, in the record, represented him for that plea agreement, which, yes, could have taken years, but also could have taken 30 minutes. We don't know. In turning to counsel's argument about whether or not the ADA Bear's understanding of the defendant's prior convictions and whether or not ADA Bear should have disclosed this relationship to the court, this was not confidential information. This was not a situation in which someone was trying to mislead someone. ADA Bear's name was on the certified copies of conviction that were submitted in the notice of enhancement and then presented again for purposes of sentencing. And as the trial court pointed out, the defendant was just as aware as ADA Bear that this had been his attorney at the time of those plea agreements. So the defendant could also have said something much earlier in the trial but chose not to. In any event, there was no actual conflict of interest in this case. If there are no further questions about this issue, I'd like to turn to the alleged violation of Rule 16. The defendant claims that the state failed to disclose a statement that he made in a recorded interview with law enforcement, specifically a statement that he had blacked his girlfriend's eye shortly before the events that took place at City Hall. And just to clarify the sequence of events as they unfolded, after the defendant was arrested, he was interviewed by law enforcement, this special agent, and that interview was recorded. The state provided that recording to the defense. The state also created audio clips of that recorded interview that it then introduced at trial. The state provided those audio clips to the defense. And as I believe you noted, Judge Ayers, defense counsel acknowledged the existence of this recorded interview and said something to the effect of, it needs to be limited as to what exactly is presented to the jury at trial. So everyone was on the same page that this longer recorded interview exists, and then that these audio clips also existed. And basically what happened is that even though everyone was on the same page that the special agent's testimony should not get in to other statements that the defendant made during the recorded interview, for whatever reason, the special agent made a passing reference saying that the defendant had mentioned blacking his girlfriend's eye. Trial counsel objected, and the trial court immediately issued a curative instruction instructing the jury that they should not consider that portion of the special agent's testimony in reaching their decision on the defendant's guilt. And juries are presumed to follow the instructions given by the trial court.
Do you agree that we don't really know whether the defendant had the full recorded interview?
As far as I can tell on the record, they did have the full recorded interview. There's no conversation about there being any issue with the full recording of the interview. Trial counsel acknowledged that he had received the recording, and there's no mention of it being separate or multiple recordings. So as far as I can tell, they received the entire interview as it existed.
But you agree there was a redacted version, and that's all that we have in the record?
That's all that we have in the record, yes, Your Honor. As the prosecutor described, he painstakingly trimmed that sort of the larger interview into 10 individual audio clips to try to keep out some of that sort of bad evidence about the defendant. And despite those efforts, it didn't work. The special agent then mentioned the blacking of his girlfriend's eye, and the trial court issued a curative instruction. But you're correct that we do not have the full interview. So we do not know if that comment that the defendant made about blacking his girlfriend's eye, if it was contained within that interview. It would seem that it was, because there's no evidence that the defendant and this special agent had any conversations outside of that interview back at the station. So as far as we can tell, the defense would have, they had the full interview, they had the audio clips, and there was no ambush or any sort of unfair surprise at trial. If there are no further questions about that issue, I would rely on my brief as to the sufficiency argument. And if there are no further questions about anything else, I'd ask this court to affirm the judgment of the trial court.
Any questions? Thank you.
Thank you.
Ms. Butler, you've got your 3 minutes.
Two quick points that I want to touch on from the state's argument. Number one, state mentioned that Mr. Overstreet also would have been aware that he was represented by ADA Bear previously, but it is not on Mr. Overstreet to be aware of what the rules of professional conduct are. Even if he knew that he was previously represented by the ADA, this is a layman. This is not someone that's well versed in the legal system, and probably would not know that that is something that should raise a red flag. So it's really not on Mr. Overstreet to have been the one to stand up and say, well, didn't you represent me back in 2008? The burden was definitely on the ADA to know that, or even the district attorney's office at large to have some type of appropriate screening procedure to where we don't even get to this point, let alone that the attorney ends up being the lead attorney on that case. The second thing, just on the discovery issue, we seem to be going back and forth about whether or not we received the full recording, and the way that I see it, we did receive a recording, but the state's argument seems to be bring up any and all possibilities except for the fact that the statement that we received, the recording that we received, did not contain this conversation. So either that happened before, this conversation happened before they hit record, and we didn't have it, or we received a partially redacted version of the recording. But this idea that we absolutely received the recording, we listened to the recording, and then just simply forgot that we heard something this egregious and then decided to stand up the day of trial, I don't really know that the record bears that out. I think it's a very fair assumption to take trial counsel at their word that they received the recording, they listened to the recording, and they did not hear this in the recording. And again, it obviously would be better if we had the full recording, but trial counsel was very clear that they did not receive the full recording, or at least the recording that they received did not contain this conversation. And that, trial counsel never actually refuted that. When this came up, trial counsel never said, no, you're wrong, you received the full version. Trial counsel sort of just stammered, and then the trial court said, well, I'm gonna issue a curative instruction. And then when we get to the motion for new trial, when this came up again and they had the opportunity to say, no, you absolutely received the full recording, again, they sort of tacitly conceded that they had not done that and said that their only position on this issue was that the curative instruction that the trial court gave was sufficient. So it's really the first time on appeal that the state's arguing that they complied with the rule and that we received the full recording. If there are no further questions from the court, we ask the court to reverse and remand for a new trial. Thank you.
Thank you. All right, thank you both for your arguments and your briefs. We appreciate that, and we'll take the case under advisement. And I think that concludes our docket this morning. So we appreciate you all being with us and bearing with us during our technology challenges. So we will adjourn.
All rise.